and jurors are going to be the finders of fact. The judge is going to give the jurors the law. Jurors will render a verdict. Verdict means to speak the truth. Escambia County's Law Day program has been in existence since the early 80s. Our Law Day features an actual trial by jury, and some of you students are going to participate, jurors today. This is a real case, and the defendant and the state are interested in the jury's verdict. I wanted to congratulate Charles Godwin. He's been in charge of our Law Day program since the early 90s, and we appreciate everything he's done for our Law Days over the years.
Good morning.
Now I'm going to ask for judges and lawyers to introduce themselves, starting up in the top corner here.
I'm Doug Egerton. I am the probate judge here in the county and a proud graduate of W.S. Neal High School.
I'm Wayne Hartley. I serve as the public defender for Escambia County, and I'm a proud graduate of T.R. Miller High School.
Good morning, I'm Brooks Garrett. I'm with the firm of Thompson, Garrett, and Hines, where I practice with Ed Hines, Kirk Garrett, and Joe Witt. Believe it or not, I'm also a graduate of T.R. Miller High School.
My name is Ed Hines. I practice law here in Brooklyn, firm of Thompson, Garrett, and Hines with Brooks Garrett, Joe Witt, Kirk Garrett.
I'm Gordon Godwin. I have a practice in Atmore, a solo practice there. I'm also your public defender for city courts in Atmore, Flomaton, and East Bruton. And I didn't graduate from any of the schools here today. I went to Escambia County High School. They were here yesterday. But I do have a son, Nolan Godwin, that attends Flomaton now. He's a junior. So good to meet you.
I'm Kim Pettis. I'm your assistant district attorney, and I graduated from T.R. Miller High School.
Good morning. My name is Steve Billy, and I serve as your district attorney.
Good morning, I'm Danny White. I have a practice here in Bruton. My office is just up the road here. I am the municipal court judge for the city of East Bruton, and I'm the public defender for the city of Bruton. I'm a Flomaton High School graduate.
Mike Perry, I have an office here in Bruton, and I'm a graduate of T.R. Miller High School, just like Mr. Billy is, who forgot to say. We play football together. Go Tigers.
Good morning, my name is Sierra White. I'm a practicing attorney here in Bruton with my dad. We are White and White, and I'm a proud graduate of Flomaton High School.
Morning, White, Flomaton graduate.
Ben Brown, I'm assistant public defender for the county. I graduated from Atmore.
My name is Tim Godwin. My office is in Atmore, where I practice with my father, Charles Godwin, and both my parents graduated from Flomaton High School, but I went to Escambia County High School.
I'm Boyd Miller. I'm a private mediator and practice in Southwest Alabama. I graduated from Mountain Brook High School in 1970.
George Godwin, Atmore.
Joe Witt. I practice here at Thompson, Garrett, and Hines with Brooks Garrett, Kirk Garrett, and Ed Hines. I'm the Atmore City Prosecutor. I'm the Flomaton Municipal Court Judge, and I'm an assistant district attorney. And I went to high school in North Alabama.
Good morning, I'm Eric Cole. I'm your district judge. I'm a graduate of T.R. Miller, and I'm also the proud father of Graydon Cole, who's a graduate to be at T.R. Miller.
And I would like to say that I'm the proud father of Claire Hart and T.R. Miller.
For the record, I'm the proud mother of Bryson.
All right, right now I'm going to recognize BOP to contribute to help make Law Day possible. Sheriff Heath Jackson, chosen by other 66 sheriffs in the state as treasurer for the Alabama Sheriff's Department. Ms. Michelle McClung, Superintendent, Escambia County Schools. Mr. George Brown, Assistant Superintendent, Escambia County Schools. Michelle Collier, Assistant Superintendent, Escambia County Schools. Dr. Keith Varner, Superintendent, Brewton City Schools. Dale Ash, Pepsi. Webb Knoll, retired Pepsi employee. Newspaper publishers, Atmore News, Atmore Advance, Tri-City Ledger, and the Brewton Standard. The Escambia County Commission, the Escambia County School Board, Brewton City School Board, participating private and homeschool teachers and administrators. Now it's my pleasure to introduce Attorney Boyd Miller. Boyd Miller is a native of Mobile, Alabama. He attended law school at the University of Alabama, graduated in 1979. While in law school, he served as editor-in-chief of the Law Review. Following graduation from law school, Boyd began practicing labor and employment law at the Birmingham office of Cabanis, Johnston, Gardner, Dumas, and O'Neill. In 1983, he transferred to the Mobile office of Cabanis, Johnston. Following the transfer, he engaged in a general civil litigation practice until early 2021 when he established a practice devoted entirely to mediation and arbitration services. He has served as trial-level mediator and appellate-level mediator in over 2,000 cases, including a variety of disputes, including personal injury claims, employment issues, workers' compensation matters, and commercial disputes. Boyd is a former member of the Alabama Supreme Court Commission on Dispute Resolution and the Alabama Center for Dispute Resolution Board of Directors. He also formerly chaired the Alabama State Bar Association's Dispute Resolution Section and was chair of the Mobile Bar Association's Dispute Resolution Section. As a hobby, Boyd enjoys turkey hunting. They don't call turkeys thunder chickens for nothing. If you ever hunt turkey and you hear them gobble, you'll never forget it. Please join me in welcoming Boyd Miller.
Now, as I understand it, all I'm supposed to do is do an owl call and then I can go home. So here you go. I knew it would work. Listen, I'm glad to be here and I appreciate y'all's time. I'm not going to take up a whole lot of it. I'm going to speak on a topic that I think is very timely and will be important to all of you as you go forward in life. And that is alternative dispute resolution. I have my prop here. There you go. Alternative dispute resolution. We're here in a courtroom where disputes in legal matters have been traditionally resolved. We have judge, we have jury, we have a witness box, we have a jury room where the jury goes back and determines cases and decides everything. This is not just here in Brewton, Alabama, but you see them all over our state and all over our country. It's the traditional method where matters have been resolved for not just decades, but centuries. Now, as of about 10 years ago, more than that, 30 years ago, we have what's called alternative dispute resolution, where cases are resolved outside the courthouses, oftentimes by the parties themselves. There are two kinds of alternative dispute resolution: mediation, arbitration. I'm going to speak about both of them. They are as different as cats and dogs. Everybody knows cats and dogs are animals. They're both different kinds of animals, but they're very different animals. Mediation, arbitration are both forms of alternative dispute resolution, but they're very different animals, okay? I'm going to talk about mediation first. When I graduated from law school in 1979, I had never heard the word mediation. Literally had never heard it in my 3 years of law school. I practiced law for 13, 14 years before I ever even heard the term. And I heard these vague rumblings about mediation is going to be coming. We're going to have where people get together and decide their own cases. And I thought, well, that's crazy. That will never work. As it so often has been the case in my life, I was wrong. One day I'm sitting at my desk and the phone rings. It's about 1993. A bunch of lawyers on the conference call. They say, Boyd, we have a construction contract dispute. There's multiple parties. There's 5 parties. We want to have a mediation. We want you to be the mediator. I'd never even attended a mediation, let alone served as a mediator, but there were no mediators back in those days. So I said, okay, I'll do it. We have a mediation 2 weeks later. Case settles, not because of anything I did, and the next day my phone is ringing off the hook. All these lawyers and judges are calling, we understand you're a mediator. We need you to settle this case. I'm going, goodness gracious, 2 weeks ago I could not spell mediator, and now I are one. But in any event, I went and got all of my certifications and qualifications. Since that time, as Mr. Hart told you, I've mediated over 2,000 cases, probably bumping up on 3,000 cases. And they've included everything across the board on the civil side, because that's where you see mediation, on civil cases, not on criminal cases. They've included construction contract disputes, business divorces, automobile wrecks, industrial accidents, workers' compensation cases, slip and falls, dog bite cases, you name it. And I found over the years that mediation can be successful in getting cases resolved because it causes the parties to focus on settlement instead of on the pull of the litigation process, and it gives them the opportunity to decide their case themselves. Here's what I do when I start every mediation. I'm very old-fashioned. I get together with the parties and I talk with them about mediation. I say, I want to make sure that everybody knows what mediation involves. I want to make sure everybody knows what my role is as the mediator, and everybody understands the ground rules so that hopefully we're all singing from the same hymnal, so to speak, as we go throughout this session today. I tell them this. I know your attorneys have told you this is a settlement conference. It is that. But it is that and something more. It's an opportunity. It's an opportunity for people to get together in a private and confidential setting to talk about whatever's at issue between them. I emphasize those 2 words, private and confidential, because unlike what happens at the courthouse, which is typically not private, typically not confidential, people are free to wander in and listen to testimony and look at exhibits on the board or the monitor. Everything we say and do in mediation is private and confidential. Very importantly, too, it's an opportunity for self-determination. Self-determination means the parties themselves decide their case. Not a judge, not a jury, not an appellate court in Montgomery. The parties themselves, sitting right here, get to decide this case, and they get to decide it today. Our process is simple. At the outset of the mediation, I'm going to ask the attorneys to give me an overview of the case. I may ask them some questions as we go along. After that, I'll meet with the participants privately. I'll ask them about settlement possibilities. I'll talk with them. I may propose settlement possibilities. I'll take settlement proposals back and forth between rooms, between the parties, but I'll be doing more than just walking numbers back and forth. As the mediator, I oftentimes make suggestions to the parties about settlement. Sometimes I strap on my devil's horns and say, have you thought of this downside or that downside when I'm playing devil's advocate? When I do those things, I'm not trying to favor any particular participant in the mediation. I'm simply trying to keep everybody focused on settlement, thinking about settlement, so hopefully we can have a settlement in place at the end of this session. There are some rules that apply to mediations in Alabama generally, and I tell them these rules apply to your mediation very specifically. First of all, as I said earlier, this is confidential, so what happens at mediation stays at mediation. Second, in order to promote the free exchange of ideas in this process, the law in Alabama says I cannot be called to testify as a witness as to what was said and done at mediation. Third, the law also says the parties cannot seek to introduce into evidence in any subsequent hearing or trial what was said or done at mediation. Nobody's got to worry about anybody coming along and saying, Judge, at mediation so-and-so said this, or Judge, this was offered as a settlement. Our judges would never allow that testimony. They know it's important for people to feel comfortable as they talk to each other and the privacy and confidentiality of the mediation setting. I then close out by telling people, look, this is your opportunity to decide your case. If you don't decide it, somebody else is going to decide it for you. It's going to be a judge, or it's going to be a jury, or it's going to be an appellate court. That decision is indefinite because nobody knows when it will be or what it will be. But this is a chance to decide this case today. You can work together. If you can work together, hopefully we can construct a resolution of this case that sometimes even the courts can't come up with. They have to follow very specific paths. But if everybody agrees, we can come up with a decision that decides this case today. Now, how successful is mediation? Let me give you some numbers. The Alabama Center for Dispute Resolution in Montgomery has been tracking mediations since 1997. And from 1997 to 2022, that's a 25-year period of time, if my math is correct, they tracked 131,029 cases were mediated, according to mediators who work through their program. I'm going to ask somebody to guess how many of those settled. I'm going to pick somebody at random. All right, we've got 131,029 cases. And guess how many of those settled? It has to be a number between, I'm thinking about it now, I've got it right here. It has to be a number between 1 and 131,029. If you guess it right, let's make this even better. Mr. Godwin will reach into his pocket and give you $100 cash. You got 3 seconds. You ready? 1, 2, how many? So close, so close. 300. No, the number is 104,966 cases. That's over 80% of the cases that were mediated over that 25-year period of time. So, think of what it means when you don't have 104,000 cases that are on the dockets of the courts that have to be adjudicated. That means the judges and the juries can focus on the cases that do have to be adjudicated, whether they're criminal cases or whether they're civil cases. Now, I'm going to talk about the other part of alternative dispute resolution. Arbitration. We talked about dogs and cats. Let's say mediation is the cat, arbitration is the dog. They are entirely different. I told you that when I serve as a mediator, I don't have any power or authority to decide anything, okay? The most I can decide is where we order lunch. It's not my power to decide anything, it's within the power of the parties to decide anything. I can't compel them to do anything. Arbitration, everything is different. In arbitration, I become, if I'm selected as the arbitrator, I become the judge, the jury, and the appellate court, because there is virtually no appeal from arbitration. Arbitration involves me getting together with the parties as the arbitrator. We have what's called a planning conference where we plan our discovery, then schedule a hearing. We have a hearing. I take testimony under oath, put people under oath. They give me exhibits. I go decide the case, and that's it. There is no appeal, virtually no appeal. You may ask yourself a couple of questions. Well, first of all, why does that concern me? I'll get to that in a minute because it is going to concern all of you, everybody in this room. The other question you may ask is, well, why does anybody do that? Why would anybody do that, agree to that to begin with? Because arbitration is a creature of contract. The court can't compel you to go to arbitration unless you contractually agree to do that in advance. Typically, in the past, arbitration was exclusive to certain industries. A good example would be in collective bargaining agreements in large industrial mills. They would have a union and a collective bargaining agreement. The company and the union would agree to arbitrate their differences because it gave them a prompt resolution of matters involving the business enterprise and what was being conducted at the mill. You would have arbitrators who are oftentimes very familiar with that industrial process and very familiar even with the collective bargaining agreement itself, may have arbitrated multiple cases between those two groups. You have also in construction contracts, enormous buildings, skyscrapers, or enormous bridges being built, multiple parties. You've got owners, you've got a contractor, you've got subs on tops of subs on tops of subs. Very technical matters that are being determined there. You know, what was the weight of the concrete, da 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 da. They want somebody who's knowledgeable about the construction industry to decide that case. Their arbitrator may even be an engineer, may be an architect. That's what they want, and it's very specific to that case. Another good example would be maritime cargo contracts. You got cargo being shipped from Singapore to the port of Mobile. Something happens to it, it's damaged along the way. Well, for that case to be decided over who's responsible for that damage in court is going to take years. And you've got all these personnel who serve on these ships. They're all over the world. There's no telling where they're going to be. So they typically have arbitration clauses, and the matters would be solved in London, England, through experienced maritime arbitrators. Now, here's what's happened recently where it's going to affect y'all. About 1995, in a case that arose in Baldwin County, Alabama, originally litigated in Bay Minette, there were some homeowners who had a termite bond. Their home was infested with termites. They sued the termite company, and the termite company said, "Aha, check page 2 of your agreement here. It's got an arbitration clause." The homeowner said, we don't have to do that. And the termite company filed a motion to compel arbitration, which was denied by the Circuit Court of Baldwin County. Termite company appealed to the Alabama Supreme Court, denied. They don't have to arbitrate. There's a provision in Alabama statutory laws that these arbitration provisions are not enforceable. Appeal to the highest court in the land. I'm talking about up there where they're looking down on the clouds, United States Supreme Court. Guess what? You got to arbitrate. It touches on interstate commerce, and therefore the Federal Arbitration Act, which preempts state law, means you got to arbitrate. Since that time, the floodgates have been opened. And what you will see continuously throughout your career as you go forward is arbitration agreement after arbitration agreement after arbitration agreement. For instance, suppose you're going to buy a car, whether it's new or used from a car dealer. I guarantee you there's going to be an arbitration agreement in there. If you have any type of financial transaction with a financial institution, there's going to be an arbitration agreement in there. Open up a stock account with a stockbroker, arbitration agreement in there. If you, employment contracts, very, very likely to see if you're being hired by a company, flip down to their arbitration agreement, okay? If you, this is my favorite, when you get, we all see when we're on our computers, and so that we have new terms and conditions, please read and accept. And so then you look at it, and there's 80 pages of gobbledygook written by some lawyer out of Silicon Valley. And at the very end, of course, nobody reads that junk. At the very end, there's a little box for you to click. I have read and agreed to these terms and conditions. Click. Go back to about page 60, and there's an arbitration agreement in there. And it probably says you're going to have to arbitrate it in California using California law. So, arbitration has exploded. It's here, at least for the time being. There are some complaints about it. Businesses love it. Some consumer advocates don't love it. They think that it's not fair to the consumers, but whether or not you like it, at this point, it is there, and you need to be aware of that. Can you say, if you're dealing with a financial institution, taking out a loan, what have you, I don't want to agree to arbitration? Sure you can. Good luck with that. They'll say, we're going down the road. And then you go to the next one, and they'll say, sign our arbitration agreement. I would like to think that over time, there will be some effort to winnow out arbitrations and consumer agreements, but I think you're going to see that, at least for the time being, in a lot of situations. Couple of final things. What does an arbitration agreement look like? Cats and dogs. We're back to cats and dogs. Mediation cats, arbitration dogs, both forms of alternative dispute resolution. An arbitration agreement, just like a dog, there are all kinds of dogs. There's big dogs, little dogs, medium-sized dogs. There's brown dogs, tan dogs, black dogs, white dogs, spotted dogs. Arbitration agreements could be anything. They are written by people. They may call for one arbitrator. They may call for 3 arbitrators. They may call for an arbitration forum to be the forum for resolution, like the American Arbitration Association. It's pretty much across the board, and it's whatever the parties have agreed to will be likely enforceable. So there you go. Now you know all about alternative dispute resolution, mediation, and arbitration. You know about cats and dogs. Let me leave you with one thought. Civility. That's one of the things that Jim Hart talked about. It's what the American Bar Association is trying to promote this year, specifically this year, among other things, 2023. Civility. They're, of course, concerned with the court processes, but I think also concerned with something bigger, a bigger picture, civility in our civilization as we go out into the world and how we treat each other. I have personally noticed an uptick in how people can be uncivil these days. I saw 2 days ago a passenger on an airline who didn't get the seat he wanted. He didn't like his seat assignment, and he punched out a stewardess. Come on, what is that good for? Why is that? People seem to think that it's okay to be mean and rude in a lot of circumstances that they didn't used to feel. It's not okay. And I would encourage everybody to think about being more civil. As Ellen DeGeneres used to say at the end of her show, be kind to one another. And that's my message to you today. Thank you.
Thank you so much, Boyd. It's hard to say how important alternative dispute resolution is, but the cost of litigation is astronomical, and that's why the alternative dispute resolution is such an important area of the law. At this time, I'm going to dismiss the attorneys and officials not involved in the case. And I'm going to turn the program over to Circuit Judge Todd Stern.
Thank you, Mr. Hart. Let me say while Mr. Hart is here that this program as it exists today was started by Mr. Hart's father back in the 80s. And without his efforts, we would not be here today. And you're here today. Some of you will serve on the jury. And this program is one of its kind in the state of Alabama, and that's all thanks to Mr. Hart's father and Ms. Claire Hart's grandfather. So let's give them a round of applause. Thank you, Mr. Hart.
Thank you.
Good morning, everybody. I'm Todd Stearns. I'm one of your circuit judges here in Escambia County. The other circuit judge was seated to my right. He had to leave on an issue. That's Jeff White. He's a proud graduate of Flomaton High School. And we serve as your circuit judges. Circuit judges are your court of original and equitable jurisdiction. So we handle felony criminal offenses, we handle divorces, property disputes, protection from abuse, anything and everything we have to handle. You've heard from Mr. Eric Cole. He's our district and juvenile court judge, and he has a lot of responsibilities. He has to handle juvenile court. That involves juvenile delinquencies and dependencies. And as district court, he handles civil and criminal matters, primarily misdemeanor jurisdiction. He's very busy, and we appreciate his efforts. I'm going to introduce the other court personnel. Seated immediately to my left is John Robert Fountain, our circuit clerk. He is one of the most important people in the court system in this county because he is responsible for maintaining court files. Everything that gets filed, he is responsible for ensuring the integrity and maintaining those files. He's doing a wonderful job, and we could not function without Mr. Fountain. Sheriff Jackson is our sheriff. He's done a wonderful job. We appreciate his efforts. We also appreciate his support of the Law Day program. We have Ms. Judy Wilson. She is Judge White's judicial assistant. We have Linda Young. She's one of our judicial assistants and serves as our jury coordinator. Ms. Monica Clayton is Judge Cole's judicial assistant. She's helping me this morning. My judicial assistant is unable to be with us. That's Carrie Powell. She's not here today, so we appreciate Monica helping me this morning and keeping me straight. We have Samantha Hanks, who's an assistant with the Public Defender's Office. You've heard from Judge Egerton earlier. We appreciate Judge Egerton and what he does. Also want to thank everybody that Mr. Hart mentioned, specifically the boards of education. Without them, we wouldn't have this program. They assist us in putting this program together. We appreciate Pepsi and Mr. Webb Nall. He has been with us every year for a number of years. They provide refreshments, and we will be on break. They'll be providing the refreshments that you have. So we appreciate Pepsi's efforts, and specifically Mr. Nall. Mr. Nall in the back, we appreciate you, Mr. Nall. Thank you for the Board of Education members, both the county and the city. They support this program, and we appreciate it. As I said, we're unique. We're the only circuit in this state where high school seniors will be able to serve on a jury, a real criminal case. All right, so Mr. Fountain, do you have our list of jurors? Okay. Let me mention a few things before we call our jury. When we take a break, restrooms are down in the basements. So we will have a break after the state presents its case. You can proceed downstairs to the restrooms. There will be, as I said, refreshments provided. They will be out front. Before we get started, if you have a cell phone, please silence your cell phone or turn it off. If the bailiffs see you using your cell phone in court, they have the authority to confiscate it. You're not supposed to be using your cell phones in court. So please be mindful of that. When your name is called by Mr. Fountain, if you will make your way up to the jury box, start filling the back row up to the first row. So before I do that, let me recognize two people. We didn't mention our court reporters. Our court reporters are really the most important people in the courtroom because they're responsible for taking down what happens. If a case goes to a higher court, if it doesn't appear in their transcript, it didn't happen in court. Judge White's court reporter is Patrice Bradley. I don't see her with us this morning, but my court reporter, who's seated down here, she'll be taking everything down, is Denise Carly, and I certainly couldn't function without her. She has many other titles. She's our drug court coordinator as well. She has a passion for that. She's been doing that since 2002, and we appreciate her efforts. All right, Mr. Fountain, you ready?
Yes, sir.
All right.
Great and Cole. Claire Hart. Markel Nicholson. Saban Odom. Joseph Pettis. Lauren Thompson. Jonathan Carter. Wendy Aguirre. John Paul. Christian Smith. Lakin Stone. Deontay Everett is absent. Levi Presley. Destiny Hanks. Anaya Kyles. Bryson Patterson.
Should be 14, Judge.
Thank you, Mr. Fowler. Are you ready?
Yes, Your Honor.
Good.
Yes, sir.
All right. If I could have the jurors stand, raise your right hands. Do you solemnly swear or affirm that you will well and truly try all issues joined between the defendant and the state of Alabama and render a true verdict thereon according to the law and the evidence, so help you God? If you do, say I do. I do. Okay, you can put your hands down and be seated. Okay, ladies and gentlemen of the jury, before proceeding, I want to explain some of the rules and procedures that will be followed by you and me during the trial of this case. This is a criminal case this morning, and the procedure will be as follows. Counsel for the state of Alabama will make an opening statement for their case. Then counsel for the defendant will then respond with a statement of their defense. Each side will be confined to an outline of the case and a statement of what they expect the evidence to show. These statements are not evidence. They are given to you to familiarize you with the case so you will be acquainted with the contentions of each party. In receiving evidence, you should bear in mind, as officers of the court, that the attorneys have a duty to present evidence on behalf of the parties that they represent. They have a duty to make objections as they deem proper and to fully argue their party's cause. An attorney's statements are not evidence, but are to help you understand the evidence and to apply the law. Therefore, you should consider in your verdict only statements supported by the evidence and by the law as given to you by the court. Likewise, statements made by the court are not evidence and are not to be so considered by you. Following the opening statements of the counsel, witnesses will first be called by the state of Alabama to testify. After the state has presented witnesses, the defendant will be permitted to call witnesses to testify if they so choose. All witnesses will be sworn and will testify under oath. Their testimony will be evidence. There may be exhibits that are offered into evidence, and if they are received by the court, they will be evidence. It will be upon all of this evidence that you will use to arrive at your verdict. And when a judge and jury sit together as a court of law, it is the duty for the judge to see that the trial progresses in an orderly fashion, to rule upon all legal matters that are presented, to define the issues involved, and to instruct the jury, to instruct you as to the applicable law. It will be your duty as the jury to follow the law as stated to you by me. You will therefore render a verdict in accordance with the facts that you will determine from the evidence and apply them to the law as given to you by the court. What the true facts are. In doing so, you may accept or reject any part of the testimony of any witness. You can accept only the testimony that you consider worthy of belief. In determining what the true facts are from the evidence, you may take into consideration any natural interest or bias that a witness may have as a result of any connection with the case. You may take into consideration the interest or bias a witness may have shown while testifying. You may take into consideration the demeanor of any witness as to whether the witness has apparently testified frankly or evasively. You may take into consideration any matter as you would in your everyday affairs in passing on the truthfulness and accuracy of the testimony. Weigh the testimony in light of your common observation and experience. That's what we call common sense. So you weigh the evidence using your common sense, and you reach a verdict based upon the truth as you determine it from the evidence. During the trial, I will rule on objections by the attorneys as to the admissibility of testimony and other evidence. Now, you should not concern yourself with the reasons for my ruling, since they are controlled by the law. You are not to speculate as to what possible answers to questions which I do not require to be answered. So there may be an objection to the question, and I will not allow the witness to answer. You're not to speculate as to what that answer might be. The overruling of any objection to evidence is not intended to indicate any weight that you should give such evidence. Occasionally during the course of this trial, it may become necessary for me to confer with the attorneys outside of your presence, at sidebar, or in chambers. Now, should I call counsel to the bench or excuse you from the court, it will be to resolve a legal point or other matter that's not proper for you to consider. So you should not speculate on the content of any such conference, nor allow the conference or any inference you might draw from that conference to affect your verdict. Following the close of the evidence in this case, counsel will again address you in what's called closing arguments. They will discuss the evidence and all reasonable inferences to be drawn therefrom to help guide you to a true and just verdict. Counsel for the state will open the arguments, and defense will follow, and the state, because the state has the burden of proof, will have an opportunity to have the final say. At the close of arguments, the court will state to you the applicable law, and that's to guide you in arriving at your verdict. Upon retiring to the jury room to consider your verdict, you will elect one of your number as foreperson to moderate your discussion and to sign and return to the court the verdict arrived at by you. You are instructed not to discuss this case amongst yourselves or with anyone else, nor to allow anyone to discuss the case with you or in your presence until it's finally submitted to you during deliberations. Now, when we take a break, which we will after the close of the state's case, you do not discuss the case because you haven't heard all the evidence at that point. You don't allow anybody else to discuss the case with you. If anyone attempts to discuss this case with you, you have a duty to report that to the court. If anyone, members of your family, friends, or anyone else should ask you about the case this morning, you must tell them you are under the court's instruction not to discuss it. The attorneys, parties, and witnesses are not permitted to talk to you during trial. So at a break, the attorneys won't be able to talk to you. They're not trying to ignore you or being rude. They're just following the law. Even a discussion which has no relation to the case might give a bad appearance and might affect the integrity of the trial. So please avoid allowing anybody to discuss that with you. You know, I know that with technology today, we all have these little smartphones, computers in our hand, and we use those for several things. We use those to make telephone calls, text, but they're also little computers that allow you to access the internet. You can't do that during this case. You are only allowed to consider what comes from this witness stand. So during your break or during your deliberations, you are not allowed to Google or search any terms or use the internet to find answers to questions that you feel were not adequately addressed to your satisfaction. You're bound only by what you hear in this courtroom. And we do not want you posting during this case anything that Twitter, Snapchat, Facebook, you're not allowed to do that. So best policy is do not use your phone at all until this case is concluded. Now, I will read you the charging instrument in this case. This is State of Alabama versus Corey Ross Carnley. And it comes to court by way of a uniform traffic ticket and complaint. And that states that on March the 11th of 2023, that Mr. Carnley did unlawfully operate a motor vehicle or other vehicle at or near County Road 10 within the County of Escambia, at or near County Road 45 in violation of Section 32-5A-191A1 of the Code of Alabama, in that he did drive or be in actual physical control of a vehicle while there was 0.08% or more by weight of alcohol in his blood. That's the offense commonly known as driving under the influence, and you may have heard that described as a DUI. Now, Mr. Carnley has said that he is not guilty, and that's all he has to say. He has no burden of proof in this case. The state of Alabama has the burden to prove him guilty beyond a reasonable doubt. So, State, are you ready to proceed to opening statement?
Yes, Your Honor.
All right, defense?
Yes, Your Honor. One matter may we approach?
Yes, you may.
The defense would request, would invoke the rules.
All right. The defense has invoked what's called the exclusionary rule. That's a rule that requires any witness to be outside the presence of what's happening in the courtroom, and that can be invoked even prior to opening statements. That's to ensure the integrity of the process so one witness doesn't hear what other witnesses are saying. So, State, if you will place your witnesses.
Yes, Your Honor. Mr. Breland, would you step out back in the room behind the court?
Yes, sir. All right. All witnesses placed?
Yes, sir.
All right, you may proceed to opening statement.
Thank you, Your Honor.
Let me, before we do that, let me allow the attorneys to formally put their appearance on the record. I know you've introduced yourselves previously, but Mr. Witt, if you'll go first.
Yes, Joe Witt, Assistant District Attorney for Escambia County.
And I'm Melissa Grasso, Assistant District Attorney for Escambia County.
Okay.
Judge Danny White, practicing lawyer here in Escambia County, and I represent Corey Carnley.
He's seated next.
He is seated next to me at the council table, yes, sir.
All right. Go ahead, Mr. Witt.
Thank you. Thank y'all for being willing to sit on the jury today. We really appreciate that. Both sides really appreciate you being willing to hear this case. I represent the state of Alabama. It's my job to prove beyond a reasonable doubt that Mr. Corey Carnley was driving under the influence of alcohol. On March 11th this year, at around 3:45 p.m., the Alabama Law Enforcement Agency officers, we commonly call state troopers, were performing a driver's license checkpoint at the corner of, or at the intersection of Wayside Road and Butler Street, close to Huxford, Alabama. Mr. Carnley approached that checkpoint driving his 2013 Dodge 1500. You'll hear that Trooper Elam approached his vehicle. When he got there, he smelled an odor of marijuana, alcohol, and he had an open container in his vehicle. He asked him to step out of the vehicle. Mr. Carnley was not able to follow simple directions. He didn't get irate, he wasn't mad, he couldn't follow simple directions. Officer Elam asked him to step over to the car, asked him to empty his pockets, kept telling him to put his feet in the car, he kept putting his feet back out of the car. He asked him when he was getting ready to arrest him for DUI, he asked him to place his hands on the car, and Trooper Elam pretty much had to position him where he needed him to pat him down for officer safety. After making the arrest, he took him to the Escambia County Sheriff's Office. At the Sheriff's Office, he had him blow into what's called a Drager machine. The Drager machine, you'll hear that explain more of what that machine is from on the stand, but it tests for blood alcohol content. And Mr. Carnley blew a .09.
Judge, I object to Mr. Witt saying what the test results were until we get to that point. Move to strike, move for instructions to the jury to disregard that reading.
It is opening statements, and the state can expect what the evidence will show, but I will instruct the jury that, as I indicated earlier, what the attorneys are saying in opening statements is not evidence. Evidence will be what you hear from the witnesses and from any exhibits. So they're right now giving you an outline of what they say they expect the case will be about.
After blowing in the Drager machine, Mr. Carnley was officially charged with driving under the influence. And we just ask today, after you hear the evidence, and you weigh that evidence, that you find that Mr. Carnley is guilty of driving under the influence. Thank you.
Mr. White?
May it please the court. Ladies and gentlemen of the jury, good morning. Thank you for participating this morning. We've been doing law day in this county for a long, long time, and it's always a pleasure and it's always an honor to host, for our court to host your classes, and we congratulate you on your big month of May when you graduate, and hope that you have a wonderful future. We hope that something we do, something we say here, something that you see here would stick with you, and maybe you would be a part of our system of government as it exists here around this courthouse. Anything from judges to court reporters to lawyers to bailiffs, there are judicial assistants and so forth. There are all kinds of jobs around this courthouse that some of you might be doing in the future. And we hope that this program helps you as jurors and you as students, that you might look into that and see what you might like to do. Hey, I might like the court report, or hey, I would like to be a judicial assistant, or maybe I want to be a lawyer one day. And so if that's the case, I'm sure that any of these lawyers that have been in our courtroom today, if you chose that you wanted to be a lawyer, any of our lawyers would be happy to talk to you about the process and about what it takes to become a lawyer. I'm sure that any of these other folks who've been introduced to you today would also be willing to talk to you about what they do and how to go about being educated and getting that job. So take that with you. I hope that you get something out of that part of today, if nothing else. We also hope that you listen to this case, as far as you jurors, that you listen closely to this case, and that you pay attention to all of the details of this case. It's an important case. It's a real case. This gentleman was arrested on March the 11th, as Mr. Witt ably told you. March the 11th, he was arrested for DUI. Corey Carnley is my client. He's seated here. He may or may not testify today, so you may or may not hear from him. We'll make that decision at a later time. But this is a real case. It has real consequences. In your future years, if you are arrested for a DUI, you will go through this same process that you're experiencing today, but from that seat at that table. And so we hope that you will pay attention to it, that you will learn something from this event today, that you will learn something from being here, that you will learn something about the law. Just pay attention to the details of this case. Mr. Carnley is 31 years old. He lives in Frisco City. He got up this morning and he put his pants on and his shirt on just like you guys did. And for you ladies, just like you put your dress on this morning or your pants. He is presumed to be innocent, as the court has already told you. He's presumed to be innocent. It is not our duty, my duty as his lawyer, to prove to you his innocence. He is innocent. As flat out as you can think about it, he is innocent. The burden today is on the state of Alabama through this trooper that the state will be calling as a witness and maybe any other witnesses they have to prove that Mr. Carnley is guilty of this offense beyond a reasonable doubt. So we would ask you to consider the facts as you hear them and to consider the testimony. And we believe that after you hear all of this, even though it may sound like it's a tough case for us, it's not us, it's not we that have to prove the case. It is the state that must prove his guilt beyond a reasonable doubt. And we believe there are some things, as you heard, by the way, the speaker earlier talk about collaboration and talking about working together. This is a case that we couldn't work together to resolve. So you've got to resolve it. So we want you to hear the evidence and you resolve it. We dispute that he was guilty of DUI. The state wants to prove that he was guilty of a DUI. So we ask you to be our dispute resolution today, as you've heard our speaker speak about this morning. We believe that when you hear all of the evidence and you hear all of what happened on the scene and you watch the video that may take place, we believe that you'll find Mr. Carnley not guilty of driving under the influence. And we thank you for your time serving on this jury today, and we hope that you have a great experience. Thank you.
All right, Steve.
Your Honor, we call Jeremy Elam.
All right. All right, if you'll step up, raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, nothing but the truth, so help you God?
I do.
All right, if you'll have a seat, if you can adjust that microphone. Now, that button down there that says push, if you'll hold that down until that red ring turns green. Got it?
Yes, sir.
All right. Witness is sworn, Ms. Witt.
Thank you, Your Honor. You state your name for the court.
Jeremy Elam,
Okay. And where are you employed?
Alabama Law Enforcement Agency.
How long have you been there?
Approximately 4.5 years.
Okay. Can you describe your duties there?
Enforce the state of Alabama Title Code 13A and 13 and Title 32.
Okay.
Hang on, Ms. Witt. Can everybody in the back hear? Okay.
Scoot up some more.
Scoot up a little bit, try to talk into the microphone.
Yes, sir.
All right, go ahead, Ms. Witt.
Do you have any prior experience before working for Aaliyah?
No, sir.
Were you on duty on March the 11th, 2023
Yes, sir.
at approximately 3:45 p.m.?
Yes, sir.
Okay. What were you doing anything specific at that day and time?
Yes, sir. We were doing a safety checkpoint.
Okay. Can you describe to the jury what the safety checkpoint is?
Safety checkpoint is where we do we check for license, insurance, and registration. Make sure everybody's.
May I object? I hate to interrupt the officer's testimony, but may I object? He's basically testifying about speculation of what's ordinarily done. We're not concerned with what's ordinarily done. We're concerned about what was done on this particular day.
Okay. Overrule the objection.
It is where we check for driver's license, insurance, and registration for every vehicle. Make sure everybody's obeying by the title code of Title 32.
Okay. And who was Was there other officers there with you that day?
Yes, sir.
Who, with Aaliyah or other agencies?
With Aaliyah. Yes, sir.
Was there any other agencies present?
No, sir.
Okay. And, were you following the guidelines that you set forth a minute ago? Were y'all following, was that what y'all were doing that day?
Yes, sir, we were.
Okay. And, on that day at 3:45 p.m., did you happen to come in contact with Mr. Corey Carmen?
Yes, sir.
Okay. And, let me back up a minute. Where was this safety checkpoint?
Safety checkpoint was County Road 10 and County Road 45, better known as Butler Street and Wayside Road.
Okay. Was it at the intersection or a little bit before?
Yes, sir, at the intersection.
Okay. And is that in Escambia County?
Yes, sir.
And whereabouts in the county is that?
That would be closer to Huxford.
Okay. And when you came, did you come in contact with Mr. Corey Carnley that day?
Yes, sir, I did.
Okay. Where did you come in contact with Mr. Carnley?
At the safety checkpoint.
Okay. And do you remember what road he was on?
Yes, sir, he was traveling down Wayside Road.
Okay. And is he in the courtroom?
Yes, sir, he is.
Can you point him out? And let the record reflect he has pointed out the gentleman sitting beside his attorney.
All right, so reflect.
And when he approached, or did he stop in front of you, or did he stop in front of another officer?
He stopped right in front of me and the other officer. We were right there together.
Who was the other officer?
Corporal Breachberg.
Okay. And did you walk over to his vehicle?
Yes, sir.
When you approached his vehicle, did you notice anything about his vehicle out of the ordinary?
Yes, sir. He had when asked for license, insurance, and registration, subject had a hard time providing the proper identification.
Objection, Judge, unresponsive. The witness is answering the question that was not asked, and he's not answering the question that was asked. He asked about conditions of the vehicle is what Mr. Witt's question was.
Sustained.
Did you notice anything about the vehicle? Anything about the vehicle itself?
It was a Dodge Ram. It was dirty and looked like it hadn't been cleaned out in a long time.
Okay. There wasn't anything abnormal going on?
No, sir.
Did he roll down his window, or?
Yes, sir.
Object, Judge Leading. Mr. Witt's asking yes or no questions. He's asking leading questions, and he's just walking through the testimony. We'd like to hear what the officer has to say rather than Mr. Witt.
Don't lead the witness, Mr. Witt.
Yes, sir, I'll rephrase the question. What did you do when he stopped?
I asked him to roll down his window. He did. When he rolled down his window, the odor of alcohol and marijuana was coming out of the vehicle. Along in plain view also was an open container of alcohol.
What was the open container?
It was a beer.
Do you remember what kind of beer?
I do not recall.
So when you smelled those odors, what did you do then?
I asked the subject to step out of the vehicle and conduct a proper cause search of the vehicle along with a pat down.
Okay. And did you make any observations of the defendant when he stepped out of the vehicle?
Yes, sir. Subject had glossy bloodshot eyes. Subject had a very strong odor of alcohol coming from him. Subject also had slurred speech. Whenever he stepped out, he also had unsteady balance and was having a hard time cooperating with the commands given to him.
Did you speak to him?
Yes, sir.
Did he say anything to you?
He stated he had drank alcohol earlier in the day.
Objection to what he said. Move to strike. No evidence of Miranda warnings having been issued or given to the defendant.
Your Honor, the defendant was not under arrest at the time, and I just asked him if he said anything.
Overruled.
Did you make any observations about his speech?
Yes, sir. Very slurred.
Did he give you his driver's license?
Yes, sir. He did.
Did he have any trouble resisting?
At the time, no, sir.
So he's, did you ask him out of his vehicle?
Yes, sir. I sure did.
Did he get out of the vehicle?
Yes, sir. He did. He was stumbling.
Did you observe him walk?
Yes, sir.
What were your observations?
Subject was having a hard time putting one foot in front of the other, using the vehicle to lean on.
Did you notice anything about his appearance?
No, sir.
Clothes, anything like that?
He looked like he just got done working.
Okay. Did he say, volunteer any information to you at this point without you asking?
That I recall, no, sir.
Was that answer no? Sorry.
I do not recall.
Okay.
Did he say anything? What did you do next?
At that time, I observed, due to the heavy traffic in the area, and talking to the subject and observing him, I asked the subject to sit in front of my patrol car.
Okay. Did he get in your patrol car?
Yes, sir.
Okay. When he was sitting in your patrol car, did you ask him anything else?
Yes, sir. I asked him how much, when going to the patrol car, I asked him how much had he had anything to drink today.
Okay. What did he tell you?
I object, he's still not Mirandized, he's clearly placed into custody, he's in the officer's car, he may not be in handcuffs, but he's clearly in custody.
Your Honor, he's not been placed under arrest at this point, he's just walking to the
Judge,
car.
Judge, his freedom has been taken from him, he can't go, this gentleman doesn't have an opportunity to leave when the officer directs him to go and get in the squad car. That's as much of an arrest as locking you up behind bars.
Your Honor, he's not been placed under arrest, he's not been cuffed, Your Honor.
Judge, we disagree. We vehemently disagree because his liberties he's been detained. He's not free to leave. That's as much of an arrest as you can get. He may not have said, you are under arrest, but he is practically under arrest. He's not able to leave this scene. If he would have gone and gotten in his truck and took off, they would have certainly come after him. He's not free to leave.
Overrule the objection.
What did he tell you?
He stated he had drank several earlier.
Did he say how much earlier?
No, sir. He said earlier in the day.
When he got in your vehicle, did you ask him to do anything?
Yes, sir. Empty out his pockets.
Okay. Did he empty out his pockets?
Yes, sir.
When he was emptying out his pockets, did you observe anything?
Yes, sir. I kept telling him to stay inside the vehicle. He kept trying to take his right foot and put it outside the car and would not obey orders given to him at the time. Subject kept mumbling about what he had in his pockets. Very slurred speech continued. Uncorporization. Every time he would try to reach his foot, his right foot would go out as if he was trying to get out of the car whenever he was told to stay in.
Did he act irate?
I would say passive aggressive.
Okay. At that point, did you ask if he could perform any field sobriety tests?
Yes, sir, I did.
Okay. You asked him if he could?
Yes, sir.
Okay. What did he tell you?
Subject stated that at the time I was trying to, I asked him if he would. He was being very uncooperative, so at the time he would not, he was unable to perform them because of his passive-aggressive actions when not listening to the trooper.
Okay. So did he indicate he could understand anything you were telling him?
He was having a hard time understanding.
Based on your training experience and based on your observations of the defendant, did you form an opinion on whether he could drive a vehicle safely?
Yes, sir.
And what was that opinion?
Object, Your Honor. It invades the province of the jury. That's the ultimate question for the jury, not for this officer.
Your Honor, he can just decide is, whether or not he can drive safely.
Okay, well, that's not an element of this event, so overrule the objection.
Could you repeat the question?
Yes.
Yeah, I believe that the subject was unable to drive the vehicle.
What did you do next?
I told the subject, I placed him on arrest for driving under the influence.
Okay. Then did you transport him to the jail?
Yes, sir, I did.
Okay. Did you ask him any more questions after you placed him under arrest?
I asked him if he would blow into a Drager.
Well, before, did you ask him anything at the scene? Did you tell him anything at the scene?
I told him we was going to go to the jail.
Okay. Did you ask him any more questions at the scene?
No, sir.
Did you at any point feel it necessary to read him his Miranda rights?
No, sir.
When you, so where did you take him?
I took him to the Escambia County Jail in Bruton, Alabama.
Okay. And what did you do when you got to Escambia County Jail?
I bringing him into the booking area. I then went to the room where the Drager was stationed.
Okay. Did you explain to him what the Drager machine was?
Yes, sir.
Can you explain to the jury what the Drager machine is?
The Drager machine is a machine that we use to determine the blood alcohol content of somebody that had been driving under the influence.
Okay. And did you follow the necessary steps to explain to the defendant on implied consent?
Yes, I read the subject implied consent also.
Can you explain to the jury what implied consent is?
Implied consent is a law that when read to it, you have the ability to determine, you don't have to have an attorney present, you have the ability to determine whether you want to take the test or not take the test, but it is determined whether if you do not take the test, your license will be suspended for a period of 90 days. If it's not the 1 to 5 years, if you even own a CDL driver's license, you would not be able to have a CDL driver's license for a period of 1 year if you refuse that.
Did this defendant have a CDL?
No, sir.
Did he indicate he understood the implied consent?
Yes, sir.
Did you administer the Drager to the defendant?
Yes, sir.
And is that device designated for use by your agency to test someone suspected of being under the influence of alcohol?
Yes, sir, it is.
What agency licensed you to use the device?
Alabama Law Enforcement Agency.
Okay. Are you certified to operate the Drager?
Yes, sir.
Who certified you?
DFS, Department of Forensic Science.
Okay. And when you administered the test, did you follow the procedures approved by Alabama Department of Forensic Science?
Yes, sir.
Does this device, this Drager, does it do a self-test or self-diagnosis before each test
Yes, sir, it does a self-check.
and after each test?
Yes, sir.
Did the machine pass the self-test?
Yes, sir.
Based on your training experience and the observations you made that day, was the Drager working properly
Yes, sir, it
at
was.
the time of the test?
Yes, sir, it was.
Did you observe the defendant for 20 minutes prior to giving the test?
Yes, sir.
And what is the purpose for the 20-minute observation deprivation period?
The purpose is if he had anything in his mouth, any raw alcohol, it would dissipate at that time, or if he had anything that way, so it gets an accurate test whenever blowing in the machine.
Okay. Did the defendant, and you observed the defendant for that 20 minutes?
Yes, sir.
Okay. Did the defendant cough, burp, hiccup, vomit, or place anything in his or her mouth during the 20 minutes prior to administering the test?
No, sir.
Okay. When you administered the test to the defendant, how many times did he or she give a breath sample?
Twice.
Okay. Based on those 2 breath samples, was a breath of alcohol content reported?
Yes, sir, it was.
What was the lowest reported blood alcohol content?
.09.
Okay. And is that, .09, is that above the legal limit in the state of Alabama?
Yes, sir, it
What's
is.
the legal limit in the state of Alabama?
.08.
I want to show you what's marked States Exhibit 1. Can you tell the court what that is?
It is a certified copy of a breath alcohol analysis from Department of Forensic Science.
Okay. And is that the certificate from when Mr. Carnley performed the test?
Yes, sir.
Okay. And what was the result of that test?
It reported a breath alcohol analysis of .09.
Okay. Is that your signature on that?
Yes, sir, it is.
And is that a true and correct copy of the Mr. Carnley certificate from that day?
Yes, sir, it is.
Move to admit Exhibit 1, States Exhibit 1.
Objection.
All right, stage one is in evidence.
Your Honor, may we publish this to the jury?
You may.
Now, I want to show you what's marked as States Exhibit 2. Would you hold it for a second?
Yes, sir.
Did you have a body cam on that day?
Yes, sir, I did.
Okay. And did it film the entire incident?
No, sir.
Okay. Can you tell the court or the jury during the course of the events that day where the video starts?
The video starts as asking the subject to come and sit in my vehicle.
Okay. And on your body cam, are you qualified to operate that recorder?
Yes, sir.
Okay. And that recording was at 3:11 on March 11th, 2023 at around 3:45 p.m.?
Yes, sir.
Okay. What equipment is your body cam?
It's an Axon 2 body camera.
Okay. And was it working in good order that day?
Yes, sir, it was.
And did you use the proper procedures in turning on your body cam that day?
Yes, sir.
And have you watched the DVD in that wrap?
Yes, sir.
And is that DVD a good reproduction of the events that occurred that day?
Yes, sir.
Is that the exact DVD? You have seen that DVD right there?
Yes, sir.
And is that your initials on the DVD?
Yes, sir, it is.
And is that a true and correct copy of the video taken from your body cam?
Yes, sir, it is.
Move to admit States Exhibit 2.
Judge, we would object, but we would object to its admission at this point, and actually prior to that, I should say that I'd like to take you on board ire about the video not being the entire incident.
Okay, you may do so.
Good morning, officer. How you doing?
Good morning.
Officer, you testified just now that the video is not the entire incident.
No, sir.
Tell the jury why it's not a complete video of this whole incident.
As the traffic was picking up and dealing with a subject that was uncooperative, the body camera was not turned on at the time.
So is it up to you when to turn it on? You have to turn it on, right?
Yes, sir.
So it's all on you to turn it on.
Yes, sir.
So when you approached my client's truck, you're out there, you're working a detail, stopping folks and checking them, right?
Yes, sir.
Why would you not think of turning the video on when you approach my client's truck?
What's the question?
Why would you not think to turn it on as you approached my client's vehicle at his door so that you get the whole thing?
At the time, we figured to turn it on.
So it was not until moments later, when he's walking back across the intersection, that you turn on the body cam. Is that correct?
Yes, sir.
So we don't have the courtesy of the video of him in the truck, or him getting out of the truck, or him stumbling, as you said, or his bloodshot eyes, or his slurred speech. We don't have the benefit of that today, do we?
I object. This line of questioning is more on a redirect, not a voir dire to determine whether the videos are going to.
Well, you're getting a little beyond the scope.
Yes, Judge, I'll draw it back in. So let's go forward. So you got some of the incident, all that part about, you talked about on the, when he was putting his leg out of the car and all that stuff, that's on video. But then when you take him out of the front and put him in the back of the squad car, the video stops, correct?
After he was inside under arrest.
Yes, after he was under arrest. There's no video from there to the sheriff's department, or no video on the Drager, is that correct?
No, sir.
None of that's video. Why not?
Policy says we don't have to have it on.
So policy says you don't have to video that part of it?
No, sir.
Okay. So just the fact that the first part of it's not videoed by you, that was just on you?
Yes, sir.
You, in retrospect, you think you should have videoed the whole thing?
Hindsight 2020.
Okay. No further questions.
Your Honor, we once again move to admit State's Exhibit 2 into evidence.
Mr. Breland, has that video that's being offered as States 2, has that been altered in any way?
No, sir.
That's the whole video.
Yes, sir.
Has it been digitally enhanced or altered in any way?
No, sir.
Okay. Exhibit 2 is in.
I'd like to publish that and play that to the jury.
Okay, if I could have the attorneys approach. Okay, order in the court. Quiet down.
There's not any sound at first.
Yeah, 30 seconds.
And this is not related to him here. It picks up right here.
Got that, man? Get. 1, 2, 3. Okay. Come on over here for me, okay? Hey, man, when was the last time you had that little bit of alcohol?
It's been a little while ago.
All right, sit up in here for me, okay? Take that right there.
I'd rather not, but
Yeah, you're right here. Okay. Got anything in your pockets, buddy?
money.
All right, go ahead and let's double check it, all right? Pull everything out of your pocket. Ain't got no Derringer or nothing in there, do you? I got you. Let me see you back. No, keep your foot in there. Keep that right foot in there for me, okay? All right, there go you well.
I got some screws and nails in the back pocket.
All right, let's get those out.
Actually, it's their key. That car there's the key to their house, so I gotta have that.
Hey, sir. Rick. Hey, man, hold up a second. All right, go ahead. Let me see your other foot. See you been drinking too?
No.
Oh, keep your foot in there, buddy. I told you to keep your right foot in there.
I was trying to reach in my pocket.
Okay. Well, you can do that from where you at.
A little bit harder, but it's just changed, man.
All right, we'll keep that in your pocket, all right? Let me check your pockets. All right, lean over to your right. All right. Now let me check your left. All right, money. All right, you do? All right, I got you. What do you think it is? Yeah, you're gonna go to jail tonight, all right, look. What's for? All right, DUI. DUI? Alcohol, yes, sir. Hey, Randy, I'm going to jail DUI. Hey, get in the car. Get in the car. Get in the car. Yeah, get in the car. Stay in the car. You stay. Get that car, good. Hey! Hey, come back. That's his key. Is this down the window? Yeah, can you put that in the car? Yeah, just a second. Just a second. Hey, you go ahead and add something. No. Hey, he said this is your key? You ain't been drinking also, have you? Okay. I got you. He's going to go to jail for DUI today. Oh, hey, can one of y'all drive that? Alright, come on, Greg. Hey, is he good with him driving? Hey man, go ahead and step on that for me. Don't give me no problems, alright? Alright, because you already tried to give me problems, alright? Go ahead, I do your favor. I'm giving all this. Yes, alright, spread your legs for me, okay? Alright, spread them. Alright, come on. You're good. I said spread them, lean at that hip. Come on. Alright, stay just like that, alright? I'll be right back. Just breathe in. All right. Hang on. All right, we'll put your hands behind your back. All right. No, keep them straight. All right, come on. Left hand. All right. All right, put the back of your palm. Just make you more comfortable, okay? Go ahead. Come on. Hey, Wesley. Sit down. Hang tight. Let your head for me, okay? All right.
Okay, settle down. Remember, this is court. We have a real trial going on, okay?
Trooper Elam, when, on the video, when you have him to spread his legs and put his hands on the car, what are you doing when you can't see what's going on?
I'm finished patting him down, make sure that there is nothing else in his pocket besides his money.
Okay. And what is your purpose for doing that?
For officer safety.
Did you find anything when you did that?
No, sir.
No further questions, John.
Mr. Wade, you ready to cross examine?
Yes, sir. I'm not sure what time I'm scheduled for a break. Do we do that or?
Grace was scheduled at 10:45.
Okay, I'll be back.
We can go ahead and do that now if you want.
It doesn't matter, Judge, whatever the pleasure of the court.
How long do you think you anticipate it may be lengthy?
15, 20 minutes, maybe. We may have to watch some of that video again.
Okay.
I anticipate.
Why don't we go ahead then, and let's go ahead and take our break. Okay. We are going to be in recess until 10:45. That gives you about 20 minutes. As I said, Pepsi truck parked out front, Jacobs?
Yes, sir.
Okay, and you'll help them get down there, is that correct?
Yes, sir.
Bathrooms are in the basement if you need to use the restroom, okay? Let's go ahead and.
All right.